for several weeks to see if we can come together on a bipartisan agreement on spectrum legislation. These talks continue to make progress, and I appreciate the good faith effort on both sides, and especially where the real work gets done at the staff level. And I think we all know and are keenly aware that time is of the essence, and we need to move to a conclusion at an appropriate time, given the needs of public safety and the anniversary of 9/11. Meanwhile, though, our subcommittee can walk and chew gum at the same time, so we have many other issues before us, including FCC process reform, which is the subject of today's hearing. We have before us a diverse panel of experts representing industry, think tanks, consumer groups, academia, and the states to testify on ways to improve the transparency and accountability of the FCC. To keep our discussion grounded, I've also circulated to my colleagues on the subcommittee and these experts a discussion draft of legislation. Again, I point out it's a discussion draft. That's what we're going to have today. I view that legislative language as a starting point for today's conversation, and I thank all of you for your thoughtful analysis of the draft legislation and your testimony. I've heard from many who track these issues that they appreciate actually having a draft document to review from which to make more informed comments. Perhaps a process we could institute in certain independent agencies. This is the kind of process I'd like to see used more often at the FCC. I look forward to you sharing your thoughts and ideas and best practices for this agency. Now, at our last hearing, we heard from the FCC chairman and his fellow commissioners. They testified on what was working at the FCC, recent improvements in the FCC's processes, and what could still be improved. The hearing has made me an optimist. Chairman Janikowski explained the agency has already improved the transparency of the Commission in several regards by publishing the specific text of proposed rules, by releasing orders shortly after adoption, and by proposing to eliminate unnecessary and outdated regulations. But all of this is discretionary. Congress has the authority, and I believe the responsibility, to ensure that the agency, which is conducting the public's business, does so with transparency and accountability, regardless of who is currently the chairman. It's not asking too much to have the FCC actually codify a set of best practices and then operate by them. One idea in this mold is to ask the FCC to establish shot clocks so that parties know how quickly they can expect action in certain proceedings. Another is to ask the FCC to establish a means for the public to know the status of rulemakings and other proceedings pending before the Commission. And another is to ask the FCC to establish procedures for a bipartisan majority of commissioners to actually be able to initiate a proceeding. By asking the FCC to regulate itself, we can give the agency the flexibility it needs to act while guarding against a lapse in the Commission's practices. It's not my intent to micromanage every decision, and this legislation does not do that. In considering other reforms, we must balance the need for congressional and public oversight of the Commission with the flexibility the Commission needs to promote competition in the marketplace. For example, the Administrative Conference of the United States recently recommended 60-day comment periods for significant regulatory actions, as well as reply comment periods where appropriate. One idea is to strike a middle ground requiring comment and reply comment periods of 30 days apiece, but only when the APA already requires the Commission to issue an NPRM. Another idea is to extend to the FCC the cost-benefit analyses currently required of executive agencies and endorsed just this year in President Obama's executive order on regulatory reform. Cost-benefit analyses are valuable because they require an agency to squarely address the cost of regulation, determine whether other methods may be less costly, and make a reasoned determination that the benefits outweigh the costs. If the President's requirement is good enough for the Department of Education and the Environmental Protection Agency, why not the FCC? And trust me, the old argument that such a requirement will bog down the agency just doesn't cut it. I've never met an agency that didn't use this argument, yet they always seem to find money to buy new vehicles and buildings. Finally, it may be possible to tighten the FCC's transaction review standards to harms that directly arise from the transaction before it. Such a requirement is not meant to displace the standard of review, but to focus the Commission's inquiry. If the Commission's Act empowers the FCC to review a transfer of broadcast licenses, but not other aspects of a transaction, the FCC should review that transfer of broadcast licenses and not other aspects of the transaction. That's what their underlying statute says. These ideas are not the end of the discussion, but the beginning, and I look forward to the thoughts of my colleagues and the panelists on moving forward. As I said at the outset, this is a discussion draft, and I'm open to the input of our panelists, that's why you're here, and to the input of the public and my colleagues. When it comes to improving the transparency, accountability, and efficiency of the FCC, I'm convinced we can find common ground. With that, I would yield to the Ms. Blackburn for the remainder of the time she may consume.
Thank you, Mr. Chairman. I appreciate the legislation that you're bringing forward. I do believe it's a starting point for us to address the crisis of confidence that many now have with the FCC. But we need to move the agency away from being an institution driven by activists pursuing social outcomes to one grounded in regulatory humility and statutory obedience. Congress should slam the FCC's regulatory back door shut, lock it, and return the keys to the free market. Any new regulations must require concrete examples of market failure and true consumer harm, because there is no room for additional burdens on American industries and consumers without showing just cause. We need stronger accountability and transparency of the agency to ensure that it operates within its legal boundaries. I thank you for the time, and I yield back.
Will the gentleman yield for just 1 second?
Yes.
I'd like to take time to welcome my former classmate, former Senator John Sununu. He's at the panel, and it's good to see him on that side.
Thank you very much, Congressman Shimkus. It's very nice to be here. You know, I could never get on the Commerce Committee when I was in the House. That's part of the reason I ran for the Senate. But I did notice I'm at the kids' table here. It's a little squeaky, but I'm grateful to be here nonetheless.
Thank you, Mr. Chairman.
That's fine, and we've always wanted to have you before us, and John has a lot of questions for you, Senator. I'd now turn to the ranking member of the subcommittee, my friend and colleague from California, who is nursed back to health after her surgery, Ms. Eshoo.
Thank you, Mr. Chairman, and good morning to you, to all of the members, and thank you to all the witnesses that are here today. Today's hearing continues our discussion of FCC process reform, and I think that it's important for us to keep pressing ahead on this, examine the suggestions that have been made, and hear from a variety of witnesses about their ideas and their comments on what we're considering. Last month's subcommittee hearing highlighted that the Commission has really taken some proactive steps to increase openness, transparency, and accountability. And these efforts should be applauded as we examine legislative measures that might help to enhance the FCC's effectiveness. I want to thank Chairman Walden for incorporating the FCC Collaboration Act into the draft legislation under discussion today. This is bipartisan reform, which was introduced with Representative Shimkus and Doyle earlier this year, and it would promote greater collaboration by allowing 3 or more commissioners to talk to each other outside of an official public meeting. As part of this sunshine reform, I'm very pleased that the discussion draft also incorporates federal-state joint boards. During last month's hearing, Commissioner Clyburn described how commissioners have to rotate in and out of these meetings, and how a modification of the Sunshine Act would enhance joint board recommended decisions. Allowing FCC commissioners to collaborate more freely as part of their participation on federal-state joint boards makes sense, and I think serves to strengthen our original legislation. As I noted in last month's hearing, though, I think that we need to be cautious of legislative proposals which might or could diminish the Commission's ability to protect the public interest and preserve competition. I think those are 2 very, very important values that need to be retained. I fully support reforms that will better serve the public good, but they shouldn't be done at the expense of overly prescriptive rules that limit the FCC's flexibility and decision-making process. Our witnesses today come from many backgrounds, including industry, the public interest, and academia. You bring years of experience working with the FCC, both inside and outside the agency, And so I especially look forward to hearing your thoughts on the draft legislation. So we have a lot of work to do. We have the spectrum legislation that really needs to move forward, that will usher in a new era of telecommunications, its applications in the 21st century, and we have reforms to make, and I look forward to hearing from our witnesses today, and thank you, Mr. Chairman, for holding this. I'd like to yield the remainder of my time to Congressman Doyle.
Thank you very much. Mr. Chairman, thank you for holding this hearing, and we want to thank the distinguished panel of witnesses and our former colleague, John Sununu, for being here this morning to educate us about the important issue of FCC process reform. Mr. Chairman, while I appreciate your hard work to examine ways to update FCC process, I am somewhat concerned about certain aspects of the draft bill before us and look forward to working with you on that. The most troubling part is two things that concern me is one, that we would limit the power of the Commission to impose conditions or voluntary commitments on the transactions it reviews. While conditions shouldn't serve as excuses for the FCC to permit a transaction if it fails to serve the public interest, if a merger is approved, the FCC should impose conditions it deems necessary to meet its public interest standard. It also concerns me that we would require a notice of inquiry before every single NPRM. I think that this can be burdensome, and I think this is something that is better left to the FCC. I do want to thank you for including the language of the Sunshine Reform Bill that Congressman Shimkus and Congresswoman Eshoo and I have put forward. We think that would increase transparency and improve communication within the agency. I look forward to hearing the testimony of all the witnesses today. Mr. Chairman, I look forward to working with you, and I yield back.
The gentleman yields back his time. Now recognize the chairman of the full committee, the gentleman from Michigan, Mr. Upton, for 5 minutes.
Well, thank you, Mr. Chairman, and I certainly want to welcome our great friend, Mr. Sununu, as well. The communications and tech sector is one of the largest drivers of our economy, and at a time when overall job creation remains weak and burdensome rules and red tape are keeping job creators on the sidelines, we should be doing everything that we can to unleash the creativity and innovative potential of this sector. Eliminating outmoded rules, removing regulatory barriers, refraining from imposing new ones on this segment of our economy could do a lot to help spur jobs and help us pull out of our fiscal doldrums. Chairman Janikowski appears to recognize this. While the proof will be in the pudding, he is at least saying he plans to abide by the President's executive order on regulatory reform, even though independent agencies are not required to do so. And my hope is that he will submit to us and the administration the formal plan requesting OIRA to implement the executive order. If we want to improve the regulatory environment, process reform is an obvious place to start. The FCC's decision can only be as good as its process, and while the FCC has taken steps to improve the way that it conducts its business, more can be done. Today, we will examine a draft proposal, a good one, to set statutory baselines to ensure this and all future commissions address all the issues with the same minimum sound practices. Consistency and transparency not only produce better decisions, they help create confidence and certainty that will promote investment, innovation, and jobs. An expert, independent agency should also be engaging in objective analysis. And if it looks like the FCC is prejudging an issue and justifying predetermined outcomes after the fact, the agency looks political and the public loses faith in its objectivity and expertise. It is important to recognize that this staff draft preserves much of the agency's flexibility. Indeed, in most cases, it simply directs the FCC to set its own rules on these matters. My sense is that it does strike the right balance, but I, of course, welcome input from my colleagues and witnesses. Our hope is that we can produce strong bipartisan legislation. I yield the balance of my time to Mr. Terry.
Thank you, Mr. Chairman. And during our last hearing on this subject on May 25th, we heard from the current FCC chairman and commissioners themselves, many of whom spoke in favor of the concepts contained in our draft before us today. Chairman Janikowski recognized that shot clocks could be an effective tool, quote unquote, going forward. Commissioners Copps and McDowell agreed there should be a mechanism for a bipartisan majority of commissioners to put items on the agenda meetings. And Commissioners Copps and Clyburn spoke of the need to reform the sunshine rules to allow the commissioners to deliberate more efficiently. Now, as we work through here today, we're going to get our witnesses' input to see how we improve, continue working with our friends on the other side to make this a bipartisan. Frankly, these are issues that the commissioners, past and present, have brought forward needing change. Some they can do on their own. Some need our assistance. And we want to continue to work with everybody. So I welcome the testimony from our witnesses and look forward to moving this legislation.
Do any other members on the Republican side seek time? There's a minute and a half left. Yes.
Then I yield back.
Okay. The gentleman yields back his time. I now recognize the ranking member of the full committee, Mr. Waxman, for 5 minutes.
Thank you, Mr. Chairman. Today, the subcommittee will return to the topic of FCC reform, and I commend Chairman Walden for working with us to put together a balanced panel of expert witnesses. We need to hear from diverse voices, and Chairman Walden has worked with us, Democrats and Republicans together, to assemble balanced witness panels. I also wish to commend the Chairman for the draft legislation we'll be considering today. Unfortunately, it has serious defects and would make the FCC less efficient and more bureaucratic, in my opinion, the exact opposite of what we should be doing. I am a proponent of strong congressional oversight over the agencies within our jurisdiction, and engaged Congress can help agencies perform at a higher level and serve the American public better. In some instances, it is appropriate for Congress to legislatively modify the authority or practices of an agency to enhance agency operations and the public interest. At our first hearing on this topic, I asked basic questions that will guide me in determining whether we are promoting smart regulation. And this bill does not provide reassuring answers. The first problem is that this legislation will create an undue burden on the FCC. It requires that the Commission perform a cost-benefit analysis for every rule that might impose a burden on industry. This will be costly and time-consuming. Cost-benefit analysis might be appropriate for a limited set of major rules, but in no circumstances should they become a basis for years of litigation in court. Second, the legislation undermines the flexibility of the agency to act quickly and efficiently in the public interest. If we put new prescriptive process requirements in statute, we can end up promoting slower, not faster, decision-making. For example, the requirement that the FCC conduct a notice of inquiry prior to moving to rulemaking could restrict the agency's ability to move more expeditiously in the public interest. Third, some of the requirements in the draft legislation appear to be about process for the sake of process. Provisions in the rulemaking reform section and the transparency reform section impose practices that the Commission already follows. Chairman Janikowski's tenure has been marked by greater transparency, expanded opportunities for public input, and improved information sharing with other commissioners and the public. He has shown that the FCC can reform itself without the need for action by Congress. And finally, I'm concerned that we're making procedural changes in an attempt to address outcomes with which we don't agree. Chairman Walden and others have criticized the voluntary commitments Comcast agreed to during review of its combination with NBC Universal. That appears to be why the current draft legislation radically alters the FCC's authority under the Communications Act and could eviscerate the public interest standard. Before we take steps that could prevent combinations like Comcast-NBC, we need to examine whether they are in the interest of promoting public benefits or even in the interest of the companies they are intended to protect. There are some promising aspects of the legislation. In particular, I want to join my colleagues in support of the provisions that allow commissioners to collaborate more directly. But overall, I cannot support the draft in its current form. The chairman has said he wants to work together in a bipartisan way to improve this bill. I hope we do that and produce a bill that earns broad bipartisan support. I look forward to hearing from our panel to address these issues and to receiving their advice about how to improve the FCC. Thank you, Mr. Chairman, and yield back the balance of my time. Unless, Ms. Christensen, would you like any of my time? Yield back.
Thank you. Gentleman yields back his time, and now we'll proceed with the hearing. And we'd like to welcome all of our witnesses, and we'll start with the Honorable John E. Sununu, Honorary Co-Chair, Broadband for America. And I would just advise the witnesses, these microphones you have to get pretty close to, and the button turns them on and off. And then we have the red light buttons there that control the time. And with that, we welcome our friend and colleague, Mr. Sununu.
Thank you very much, Chairman Walden, Ranking Member Eshoo. It really is a pleasure to be here. As you indicated, I'm along with Harold Ford, a co-chair of Broadband for America. We're an organization of 300 members, equipment manufacturers, broadband providers, applications providers, consumer advocate groups, economic development groups. And the focus is really on deployment and investment in the broadband industry and identifying public policy that can really ensure that it continues to be a driver of growth and prosperity in America. Certainly commend you for looking at the topic and your pursuit of improving the way the FCC operates. Without question, the focus of the discussion draft is on process, and process matters. Process is the mechanism by which we ensure better transparency, fairness, certainty, clearer timelines, and all of those help to allow investors to make investments with a greater certainty of return, and that's what promotes economic development and job creation. I do also, however, want to take the opportunity to talk in a little bit more broad terms about changes that we would like to see the committee look at within the statutory framework, because in many regards, the obsolete premises of the existing statutory framework doesn't match the structure and the competition that we see in the marketplace today. And that's, I think, a view that's shared on a bipartisan basis. Chairman Janikowski recently acknowledged that the statute is imperfect and said, as a direct quote, it would make sense to update it. The President's State of the Union address talked about the fact that we live in a business and information age, but the last major reorganization of government happened in the age of black and white TV. So these issues, and I think the comments of the committee recognize, aren't directed at any commission, any chair, or any administration. It's a matter of making sure that the policies reflect the modern age in which we live. We do have a very vibrant, competitive communication space. It's more vibrant and competitive than ever. There are always going to be aspects that we want to see operate better or even more competitive or bring down prices even faster, but it is more vibrant and competitive than ever before across the entire spectrum of voice, video, data, and other emerging internet-based services. Over the last 3 years within the broadband industry, we have seen $250 billion in capital investment. This is during a period of a very sharp and significant economic downturn. I don't think we can find many areas of the economy that have made that level of capital investment. And again, there are always going to be areas where we want to see access improved or accelerated even more. But $250 billion is real money even to the United States Congress. The Communications Act of 1934 is built on the assumption of a natural monopoly. And I think if there's one point that I want to make, it's that that is the default presumption. And unfortunately, that's not the world in which we live right now. I think legislative reform should dispense with antiquated presumptions about natural monopolies in the communications marketplace, and we should move away from industry-specific anticipatory regulation and instead treat communications companies like other businesses throughout the economy that are disciplined in the first instance by competition, not regulation. Second, Congress should affirmatively require that the FCC account for actual competition among emergent, substitutable offerings in a consistent way. The statute can't work properly without acknowledging that all the constituent parts of the broadband space, including web-based services and their implications for competition and consumers. Third, Congress should consider structural inefficiencies that sometimes bring an already sluggish regulatory process to a screeching halt. In particular, we need to recognize that the multi-commissioner structure itself can breed interagency conflict and belabor decision-making. Second, the FCC rarely produces timely decisions when measured against the pressing decisional demands of the Internet era. Third, the FCC asserts authorities that duplicate the work of other agencies, most notably in the context of reviewing mergers. Given the role played by expert antitrust agencies, there's no legitimate reason for the FCC to also assume responsibility for reviewing the competitive effects of a merger because the transaction happens to require a license transfer. And finally, the well-intended sunshine laws have the perverse effect of slowing the deliberative process by requiring things like open meetings anytime more than two commissioners wish to discuss official business. Some of these are addressed in the discussion draft, and I think that's important. But again, I come back to the premise that we need to reconsider the presumption of a monopoly that is written into both the 34 Act and even the 1996 amendments that carried the same premise. Again, this isn't about any one commissioner or any one administration. I think we really do need to reconsider the FCC's purpose and their role in a competitive 21st century environment so that we can be mindful and accomplish true reform. Certainly appreciate the opportunity to testify and look forward to answering your questions.
Thank you, Senator. We appreciate your being here as well. We thank you for your testimony. We'll now turn to Ms. Kathleen Q. Abernathy, former Federal Communications Commissioner, and now with Frontier Communications as Chief Legal Officer and Executive Vice President for Governmental Affairs. You've worn many hats. We look forward to your testimony here, and thank you for participating.
Thank you very much. Good morning, Chairman Walden, Ranking Member Eshoo, and members of the subcommittee. It is truly a privilege and an honor to appear before you this morning to talk about what is very, very important process reform at the FCC. I am Chief Legal Officer and Executive VP of Regulatory and Government Affairs for Frontier. We're the largest provider of broadband voice and video services to rural America. And as a wireline provider, Frontier is subject to regulatory oversight by the FCC. And just over this past year, we've engaged in a number of proceedings in front of the FCC, so we have current experience working with the current regulatory processes. I'm pleased to be here today to discuss your proposed reforms and some of the ways it might impact the FCC. My testimony is informed by my career in the telecommunications industry, and as you mentioned, that's included stints at the FCC, both as a commissioner, as well as legal advisor, as well as working in the General Counsel's office. And with every position, I gained further insight into the processes that go on there. In addition to this work in the public sector, and of course my current position at Frontier, I've worked at law firms and in-house, wireless, wireline, CLECs. This collective experience provides me with a unique perspective on how the FCC serves the public. I've experienced both the privilege and the challenge of serving as a regulator, as well as the opportunity to work in the private sector. And the draft legislation proposes many reform actions that I think could make a major and significant improvement on the processes, and I'm pleased to talk about them today. I made public statements during my tenure as an FCC commissioner and thereafter that relate to some of the proposed reforms. For example, I've stated and I continue to believe that the Sunshine Act is overly restrictive in prohibiting communication among 3 or more commissioners outside of a public meeting. It's perverse, but it actually works contrary to the notion of an improved collaborative spirit. It discourages creative problem solving, and it creates hurdles to timely and effective decision-making process. And I think if you do nothing else, if you reform that one rule, many of these other concerns that you have would be immediately addressed because you'd have an actual dialogue between the parties who are running the agency. When it comes to transaction review and approval, Congress has conferred on the FCC a statutory obligation to review license transfers and to either reject, approve, or if necessary, approve it with conditions. And these conditions should be designed to ensure that the transaction at issue complies with the Commission's rules as well as being consistent with the public interest. As a commissioner, I always believed that the Commission owed it to the parties to act promptly on license transfers. There's a lot of cost associated with the delays in transfers, and to impose conditions when necessary to address merger-specific harm that impact the public interest. Merger reviews shouldn't be seen by third parties as an opportunity to impose obligations unrelated to the mergers, especially if it has the unintended consequence of advantaging or disadvantaging a company as compared to its competitors. My belief is that general obligations not designed to address merger-specific harm, there's a vehicle for that. You consider and review them in the context of rulemaking process, and that's subject to notice and comment. I've also noted before that I think there is a time and a place for timelines and shot clocks. It's difficult to implement a uniform timeline for all proceedings. For example, with a particularly complex process, the FCC has to do a complex balancing between moving expeditiously to adopt a timely decision as well as gathering the data necessary. But shot clocks are very, very beneficial because it's an action-forcing event. And the challenge with the numerous issues in front of the FCC and with a statute that many would agree is somewhat outdated is that these issues are very, very difficult. There's many times no good answer. And when there's no good answer, you sometimes don't work ahead to a resolution. You kind of kick the can down the road because you're very frustrated. A shot clock would force you to just sort of address that issue and try and resolve it. I applaud Chairman Walden and the subcommittee for focusing on FCC process reform. Process and procedure, just as much as substance itself, have a direct impact on industry participants and consumers. And given the critical role of telecommunications in our daily lives and our global competitiveness, it's great, it's appropriate for Congress to consider updating and improving the framework for the FCC's deliberative process. Thank you for having this important discussion, and I look forward to your comments and questions.
Abernathy, thank you for your testimony. We appreciate your counsel. Now we're going to hear from Brad Ramsey, who is the General Counsel for the National Association of Regulatory Utility Commissions. Brad, thank you for being here. We look forward to your testimony as well.
Thank you, sir. Chairman Walden and Ms. Eshue and Ranking Member Eshue and the other members of the panel, I really appreciate the opportunity to testify today, and I commend Mr. Walden and the rest of you for holding this hearing. I represent NARUC, as Mr. Walden pointed out. Been there 20 years. NARUC, for those of you that don't know, is the group that represents all of the state public service commissions that oversee telecommunications, energy, and other utilities in your jurisdictions. If you want to know what the potential impact of these process reforms are for state commissions, protecting your constituents in state-specific preemption pleadings that get filed at the FCC, and in the broader universal service and intercompensation reform items that they consider from year to year, you want to talk to your state commission. They will tell you what the impact is in terms of their opportunity to protect the citizens of your individual states. And I'm happy for those of you, and I don't see very many in this room that I don't think already know their state commissioners, but if you don't know your state commissioners, I'm happy to provide a gateway for you. What's the hearing about today from my perspective? Well, I don't think there's any question that reform is needed, and I also don't think that there's any question that a number of the proposals included in this discussion draft will definitively improve transparency at the FCC and will definitively improve the ability to create a better record for decision making at the FCC. NARUC hasn't taken a position on every section, but we've been pushing some of these reforms for over 10 years. The draft that came out, I think it's an excellent starting point for a bipartisan bill that could pass in this Congress. So for me, this hearing, this draft is all about opportunity. You have an opportunity to finally correct the stilted application of the Sunshine Laws that does nothing to shed additional light on agency procedures, and all it does, and I know this from personal experience, is muck things up and slow things down. You have an opportunity. There are actually 2 or 3 provisions that are in this draft that make sure that everybody gets a realistic opportunity to comment on what the agency is actually going to do. Not just the people that have the most money, not just the people that have the most staff resources. You have an opportunity here to formally adopt
the highly lauded, Ms. Eshu mentioned the fact that the Commission deserves a lot of credit for a lot of the transparency measures that they've put into place. There were a couple of measures that came in the last administration. I agree. You have an opportunity here to lock those into law and make sure that future commissions do not discard them. You also have an opportunity to normalize expectations. This is a shot clock idea that's in the bill. I actually think that that's a wonderful idea. The agency gets to set the approximate time frame that they want to shoot for, and this is much better than an item languishing there for 10 years, or in my case, an item languishing there for 5 or 6 years, and the next time I hear about it from the agency is they're putting a notice out that says, you know, we'd like to terminate your proceeding because the record's stale. A shot clock gives them something to shoot at. It's a good idea. But perhaps the most important opportunity that's presented in this item are the pieces that help the agency build a better record upon which to base its decision. The decision can only be as good as the record that they are basing their decision upon. If you shortchange the decision, if you shortchange the process, you're shortchanging the American people. It's one of the reasons why when we're talking about, great, we're finally going to have some definitive deadlines or a minimum deadline that allows the state commissions who have this complicated process of approving comments to actually file comments. But another good part of this bill is it says you're going to put the text of the daggum rule out so that I actually know what to write my comments about. NARUC's endorsed that for some time. I commend the current chairman for doing it 85% of the time. I don't understand why it can't be done 100% of the time. You have ensured an opportunity here to make a real difference in the FCC decision-making process. It's long overdue. It's an opportunity that can only make better decisions come out of the, it's not going to make the process perfect, but it's going to make the decisions better, which can only benefit your constituents, the consumers across the country, and the industry as a whole. It's an opportunity I hope you take. Thank you, and I look forward to your questions.
Thank you, Mr. Ramsey. We appreciate your testimony, and we look forward to offering up some questions. We're going to go now to Dr. Mark Cooper, Research Director, Consumer Federation of America. Dr. Cooper, we're delighted you're with us today, and we look forward to your comments.
Thank you, Mr. Chairman, members of the committee. In the past 30 years, I have seen the good and bad of regulation up close and personal. In 300 appearances as an expert witness on behalf of public interest groups in 50 jurisdictions in the United States and Canada. Brad represents NARUC. I have testified before 95% of the NARUC members. In my testimony, I outline areas where the regulatory process at the Federal Communications Commission should be improved. We need reform of the ex-parte communications. We need greater reliance on independent and peer-reviewed research. We need to provide notice on the specific details of rules to afford the public the opportunity to comment on those rules. We should enhance public participation in the rulemaking process by use of multi-stakeholder groups, regulatory negotiations, and participatory enforcement. Other agencies do it. The FCC should get with that kind of program to expand input from the public and the industry in a formal way rather than the backdoor way of the current ex parte process. The discussion draft, however, causes me great concern. I look at the center of the Communications Act as the public interest standard, which is a principle on which it stands. And the language that imposes a harm-based standard, I believe, will undermine the ability of the FCC to protect the consumer and promote the public interest. The word harm occurs exactly twice in the statute, both times in a section that worries about incumbent local exchange carriers who could abuse information service providers. The words public interest occur 103 times. That is the standard at the center of the Act. Now, others will tell you why the agency does not have to adhere to the executive branch order on cost-benefit analysis. Let me explain to you why it should not. A harm-based standard is inadequate to protect the public interest in the communications sector for several reasons. First, a substantial part of the Communication Act involves non-economic democratic values of access to communication and freedom of speech, which are virtually impossible to evaluate in narrow economic terms. The antitrust laws do not do democracy. Second, universal service is a critical goal of the Communications Act that is non-amenable to a narrow cost-benefit analysis. The value of connecting households to the network is an externality that is difficult to measure but extremely important as a political, social, and economic accomplishment. No other agency does universal service. Third, consumer privacy, over which the FCC has significant authority and customer proprietary network information, is not readily amenable to a harm standard. Fourth, in a dynamic network industry, a public interest approach is much more appropriate for interconnection and non-discriminatory carriage. Under a harm standard, it would have been impossible to value the Carter phone decision, the computer inquiries, or the 802.11 Wi-Fi rules, which were forward-looking and are key elements of creating the rich communication environment we have today. This is an industry with massive positive externalities. I believe this criticism also applies with equal force to the merger review. Mergers create unique challenges to the public interest that are best dealt with during the merger review process. The problem in contemporary markets like telecommunications is not too much regulation, but too little competition. However, the lack of competition is not the result of nefarious business practices or lax antitrust enforcement. These industries show strong economies of scale and scope, which mean that very few competitors can achieve minimum efficient scale. They show strong economies of demand side, known as network effects, which make them winner-take-most industries. The challenge in these industries is small numbers providing critical infrastructure and platforms that support massive amounts of other activity. The challenge is to make sure that they are profitable and innovative, but check their tendency to use vertical leverage or market power to undermine competition. That is a very, very difficult proposition to evaluate with a narrow harm-based standard. That is a proposition that is easy to address in a merger, which creates the very problem of vertical leverage. That is what we have suffered in this industry. As always, I look forward to working with the committee to develop any legislation that is needed. I urge you to take the attack on the public interest standard out and focus on those areas where the Commission does not have the ability to act on its own. Most of the changes that we need in process can be done internally. Establish the norms for transparent, swift, enforced regulation, and once those norms are established, it will be difficult for future commissions to abandon them. The Commission should do what it can. This committee should help it where it can.
Dr. Cooper, thank you for your testimony. We'll now go to Professor Ronald M. Levin with the William R. Ornthwein, Distinguished Professor of Law, Washington University School of Law. We welcome you today and look forward to your testimony, sir.
Thank you, Mr. Chairman and members of the committee. I hope to provide a little different perspective on this bill from those of the other panelists because my specialization is not in communications law. It's in administrative law. In other words, the manner in which the legal system deals with regulatory cases in general, regardless of the agency. I don't think that perspective gives you all the answers you need for this bill, but I think it will provide some helpful insights on some of its provisions. For example, as to Sunshine Act reform, I think that perspective will tend to support the thrust of what you're doing. I know you've heard from the FCC veterans that the Sunshine Act often interferes with collaborative decision-making and forces agency heads to rely on staff intermediaries rather than talk to each other. But I think it's worth pointing out here that that critique is shared by numerous agency officials and practitioners and scholars who specialize in other fields of regulation. So I think if you go forward with the experiment in this bill, you would get strong support from much of the administrative law community. On the other hand, I want to raise some warning flags about parts of the bill that would reshape FCC rulemaking procedures. Many students of the administrative process will tell you that agency rulemaking has become progressively more complicated over the past few decades. And this happens largely because Congress and presidents keep adding refinements to the process. Each of those refinements may look appealing when considered in isolation, but in the aggregate, they make it progressively more difficult for agencies to carry out the tasks that Congress has told them to perform. So you really ought to think twice about provisions in the bill that would make it even harder for the FCC to complete a rulemaking proceeding. My statement goes into this in some depth, but I'll just focus on three areas of concern in these remarks. First, some of the new duties are ones you probably shouldn't impose at all. I really doubt that in every rulemaking proceeding that might be perceived as putting forward a burdensome rule, you should require the Commission to speculate about what performance measures to use to evaluate that rule sometime in the future. And I don't think the FCC should routinely have to specify what market failure a new rule would resolve, because market failure is not the only valid reason the FCC may have for issuing a rule. Secondly, the bill provides some practices that the Commission should want to do much of the time, but not necessarily all the time, and so you need to build in some flexibility. For instance, should the FCC have to solicit public comments twice during every rulemaking proceeding? Well, often that's very useful, especially when they didn't exactly tell you what they were planning to do the first time. But at other times, a single round satisfies all the purposes of notice and comment, and it should be enough. Likewise, should they always provide a reply comment period after the traditional comment period? Well, sometimes they should, especially when some group dumps these lengthy and controversial comments on the last day of the comment period. There should be a chance to reply, but that is not always the situation. And so you need to build in some room for the Commission to say, here, we don't need a reply, and we should avoid the delay and move forward. Finally, I think the committee should take another look at and rewrite the section that provides for the Commission to prepare a cost-benefit analysis to accompany any rule that would be burdensome. The intent here, as I understand it, is to put the FCC on a par with executive agencies, which now prepare cost-benefit analyses under the presidential executive order, and the FCC isn't subject to that order. But the problem is that the scope of the executive order is much more limited than your provision, because that order provides for cost-benefit analysis in only a small fraction of all rulemaking. And it provides that agency compliance with that order is not judicially reviewable. If you were to allow broad judicial review under this bill, you would be inviting strenuous opposition to the bill. That was one of the main worries that led to the demise of APA reform in the mid-90s. So if you want the bill to remain relatively non-controversial, you need to avoid or limit judicial review and also narrow the scope of the cost-benefit requirement. And with that, I'll conclude my oral presentation. I hope it's helpful, and I'll be happy to respond to any questions.
Professor, it's very helpful, and we thank you for your testimony and your counsel. We'll go now to our final witness on the panel, Mr. Randolph J. May, President of the Free State Foundation. Mr. May, we're delighted to have you with us, and we look forward to your testimony.
Thank you, Mr. Chairman and members of the committee. Thank you for inviting me to testify. I am president of the Free State Foundation, a nonpartisan research and educational foundation. The Free State Foundation is a free market-oriented think tank that focuses its research in the communications, law, and policy area. By way of background, I should note that I'm a past chair of the ABA's section of administrative law, and I'm currently a member of the Administrative Conference of the United States and a fellow at the National Academy of Public Administration. So today's hearing on FCC process reform is at the core of my expertise in communications law and policy, as well as administrative law. As a frame of reference for my testimony, I want to recite statements made over a decade ago by two different FCC commissioners, one Democrat and one Republican. FCC Chairman William Kennard, in August 1999, released a strategic plan entitled A New FCC for the 21st Century. The plan begins, quote, "In 5 years, we expect communications markets to be characterized predominantly by vigorous competition that will greatly reduce the need for direct regulation. As a result, over the next 5 years, the FCC must wisely manage the transition from an industry regulator to a market facilitator. The FCC, as we know it today, will be a very different institution in both structure and mission." That was in 1999. In December 2000, then FCC Commissioner, soon-to-be Chairman Michael Powell, said, quote, "Our bureaucratic process is too slow to respond to the challenges of Internet time. One way to do so is to clear away the regulatory underbrush to bring greater certainty and greater simplicity to the market," close quote. These statements provide a useful frame of reference for considering FCC reform. I support many of the reforms proposed in the draft bill, and I'll discuss them, I do discuss them at greater length in their testimony. Right now, I just want to highlight a few of the provisions and then talk briefly about one additional provision. I endorse the provision that would require the agency, with respect to the adoption of any new rule that may impose additional burdens, to analyze the market failure and actual consumer harm the rule addresses, to perform cost-benefit analysis, and to include measures for evaluating the effectiveness of the rules. The FCC has had a pronounced tendency over the years, and certainly this tendency was evident with respect to the adoption late last year of new net neutrality regulations, to adopt rules without engaging in meaningful analysis that would be required by the proposal. The requirement to analyze any claimed market failure and consumer harm before adopting new rules should force the FCC to engage in more rigorous economic analysis than it often does when it relies on the indeterminate public interest standard for authority. I'm not going to probably agree with much that Mark Cooper said here today, possibly, but he's correct that the public interest standard is found in over 100 provisions in the Communications Act. I wholeheartedly endorse the proposed changes to the Sunshine Act. They've been noted, and I won't dwell on those here, but I support those. The provision reforming the Commission's transaction review process is as important as any other provision in the draft bill. In light of the continued abuses, and I think they've increased over the past decade in the merger review process, the agency often imposes extraneous conditions after they are, quote, volunteered at the last minute by transaction applicants anxious to get their deal done. And this is after the transactions have been subject to reviews already lasting a year or more. The requirement that any condition imposed be narrowly tailored to remedy a transaction-specific harm, coupled with the provision that the Commission may not consider a voluntary commitment offered by a transaction applicant unless the agency could adopt a rule to the same effect, will go a long way to reforming the review process. My own preference would be to go even further and reduce the substantial overlap that now occurs between the Department of Justice and the FCC, and have the Department of Justice primarily responsible for assessing the competitive impact of a transaction. As I said early in my testimony, the reality is that most segments of the communications marketplace are now effectively competitive. When Congress passed the Telecom Act of 1996, it anticipated the development of a competitive marketplace, stating in the statute's preamble that it intended for the FCC to, quote, promote competition and reduce regulation. The FCC has not done nearly enough in the 15 years since the passage of the 96 Act to reduce regulation. Whatever the reason, the point is that a fix is needed, and the draft bill, while commendable in many respects, does not directly address the problem of reducing existing regulations. I don't have time to address it at any length now, but I hope you will consider adopting a proposal that I've made that would amend the forbearance provision of the Act and the regulatory review provision in the Act that were both included in the 1996 Act as to be used as clearly deregulatory tools, but have been used only sparingly, and they could be amended very simply to allow those provisions to be much more effective in achieving less regulation and getting rid of unnecessary regulations that are on the books now. Thank you very much for inviting me here today, and I look forward to your questions. Thank you.
Thank you very much, Mr. May, and thank you to all of our panelists who have given us great counsel here today. We appreciate it. Some I appreciate more than others. No, I'm just kidding. That's why we had you here. We needed the honest assessment of what works and what doesn't work in this bill. Mr. May, I think when we get into this discussion of what's in the public interest, it really is what any three commissioners decide at the time as they're reaching some agreement. It's pretty broadly determined. Is that not correct?
It's about as indeterminate, I think, as any other phrase could be. So, and I have to confess I've used that, whatever 3 commissioners say it is on any given day, many times myself. But it absolutely is. And in fact, I wrote a law review article about 10 years ago in which I counted up those provisions. That's why I know Mr. Cooper is correct. But the point is that it provides no guidance to the commission, and it does need changing.
Yeah, I want to, I seek unanimous consent to enter into the record an article by Phil Weiser, who just left the White House as National Economic Counsel to return to the University of Boulder. Without objection, we'll put this in the record. In the article, he notes that frequently the FCC seeks to leverage its authority to approve mergers to obtain concessions that often have little or nothing to do with the competitive issues raised in the transaction. I think that's at the heart of the matter of what I, at least, and I think many members on this committee are trying to get at. It's not that you ignore or eviscerate the public interest standard. It's when it's used as an excuse to go do something you don't have the authority to do through your own organic statute. Commissioner Abernathy, do you agree the Commission should not leverage merger reviews to obtain concessions that have little or nothing to do with the transaction-specific harms?
I've said that previously in speeches, and I do agree. Now, just to be clear, in transactions where I was involved with other commissioners, you do have disagreements about a public interest issue associated with a transaction. So I may think a particular condition isn't required. But this still leaves, I think, a tremendous amount of ability for the commissioners to address the issues that are raised by the transaction. You may have disagreements about whether it's really a problem or not, but I think it does leave a tremendous amount of discretion to the commissioners.
As I listened to your testimony and read it in advance, it seems like there's concurrence that having the text of proposed rules available to the public and to other commissioners is something you all agree on. Does anybody disagree with that?
Could I just respond? No, I don't disagree. You know, in theory...
Let me get an answer. Does anybody disagree with having the text made available prior to votes in the commission? Mr. Levin?
Only to the extent that as a non-specialist in this area, it occurred to me there might be a wide range of situations where that wouldn't work because it's urgent, because it's a very minor matter where you're just talking about a factual dispute and an adjudication. The public has nothing to say about it. There might be feasibility limitations. I do agree with it as a general proposition.
I would go one step further, and I would like that kind of provision to apply to merger reviews as well, so that at the end of the process, when so we have that with the Tunney Act, under the antitrust laws, we ought to be allowed to look at, the public should be allowed to comment on the merger review, the conditions that were adopted. Now, that may or may not address some of the concern about extraneous issues.
Right.
But in that further review, if things were truly extraneous, people would have a chance to comment on that, and the agency could, in fact, be informed by that process. But full comment on an actual rule is the essence of democracy, a representative democracy.
Mr. May?
I think the provision you're referring to here is the one that would require that the text that the Commission is considering at a meeting be available to the public. Right. And in response to Professor Levin's concern, I don't think your draft specifies the time before the meeting that it has to be available. So my understanding is it could be very shortly before. But in other agencies, this might not be deemed as perhaps as necessary, but as I point out in my testimony, what happens at the FCC at a public meeting, as you may know, is that at the presentation of an item, the staff before every item says, Mr. Chairman, we request editorial privileges, and the chairman says, granted, and then no one knows, no one has the text, and sometimes it's weeks before the item is ultimately released to the public, and you really don't know what's going on because of the delay in the release of the item. You don't know whether that was really editorial or not, and that's why it's useful.
And my time has run out. Ms. Abernathy, did you want to make a quick comment?
Well, the way the actual process works is that you have the text of the item that you're voting on that day, And then you're writing separate statements. Many of the commissioners are writing separate statements. And so I had never seen a situation where editorial privilege changed anything of significance in the item. But there are procedures that still need to be recognized, and I think that's part of the reasons for today's hearing, is to understand that it's not as simple as just kicking the order out the door. You still need to review it one last time, get separate statements from the commissioners. It shouldn't take a long time, but there is that process.
Thank you. I now recognize the gentlewoman from California, Ms. Eshoo, for 5 minutes.
Thank you, Mr. Chairman, and thank you again to all the witnesses. I think that you have been highly instructive to us. First off, I don't think I heard anyone say that they were opposed to the FCC Collaboration Act. Is that correct? Anyone opposed? No. I think there was consensus on that, which pleases me. To Commissioner Abernathy, thank you again for your testimony. As you know, as part of the Verizon Frontier transaction, Frontier offered voluntary commitments to build out broadband deployment and meeting broadband needs of anchor institutions, which I salute you for. I wish Congresswoman Matsui were here, because she has worked very hard on the whole issue of serving anchor institutions. At any rate, those anchor institutions within the areas to be served by Frontier. Now, none of these voluntary conditions directly address merger-specific harms, yet they confer, I think, important public interest benefits. So first, would you comment on whether Frontier would be able to offer these voluntary commitments if this draft legislation were in place as law?
I think if you spoke with Commissioner Copps, for example, with regard to these commitments, he would argue they were merger specific. I might say maybe not, but the way the analysis would go is that the whole reason for the acquisition from a Frontier perspective was for greater scale and scope. The public interest benefit was for greater broadband deployment throughout rural America. And so some of the commissioners felt, even though we said that's what we're going to do, they wanted more specific commitments associated with that broadband deployment, which we had from day one said was part of our reason for engaging in the acquisition.
Well, I support what you did. I think it's terrific. I just was trying to compare and contrast what you did with what's being proposed. Would this, what's being proposed, get in the way of what you did, or
I don't think in the context. I don't think. I'm sorry to interrupt, but I don't think in the context of our specific merger that it would have changed any of the conditions.
Do you believe in that instance that the public interest standard is preferable to a harm standard?
I'm trying to that as opposed to does not create harm to the public versus benefits the public. I think it's not a huge difference.
Okay. For all of the witnesses, I generally agree that publishing the specific language of proposed rules is a good idea. And as you know, Chairman Janikowski is making this a best practice at the FCC. This now occurs in 83% of rulemakings, which is a very significant increase over previous chairman. But I am concerned that requiring this in all instances could inadvertently undermine the goals of transparency and efficiency underlying the draft bill. So to all of the witnesses, does this requirement make sense when the Commission places a proposal from outside parties out for comment in a notice of proposed rulemaking?
I really think it would depend on the circumstance and the scope of the proposal. Anytime you require publication or even establish a shot clock, by definition, you're requiring another step. You're extending the time frame. And someone is always going to be able to argue that that's making the process more cumbersome. But you've got to balance the need and the desire for transparency with the need or the desire for expediency. I'd also make the observation that any process burden that you establish, whether it's in the name of transparency or fairness or certainty, which are all good things, is going to be as much of a burden for a deregulatory effort as it is for a regulatory effort, at least as far as it's constructed here.
Thank you. Ms. Abernathy? I don't have very much time left, so I think
I'm sorry.
we'll do a speed through the witnesses. Yes, Dr. Cooper?
Well, I want to offer an observation about this question of the opportunity to comment on the actual rules, because I believe that is, in fact, one of the really good definitions of democracy is the opportunity to write the rules under which you live. And in a representative democracy, participation in the process is really important. The thing that strikes me, and I've said this before in public, is that the problem here is not with the Communications Act or the FCC. It's with the Administrative Procedure Act. This is such a fundamental part of democracy that the implementation of the Administrative Procedure Act has deteriorated to the point where we let agencies deny people the right to speak. And so I would like this problem to be solved, and I said in my testimony in two ways. One, I think we ought to look at the Administrative Procedure Act and figure out how to make sure that the citizenry gets a chance to participate in the rulemaking. Second of all, if we want more participation, if we want more flexible and quicker rules, I believe, as a veteran of some reg-negs and other multi-stakeholder groups, that the agency needs to reach out and create formal, transparent processes where industry and public interest come together to help it. Other people do it. EPA does it, DOE does it, OSHA does it. There's no reason why the FCC can't do it.
Thank you. Thank you very much.
Cooper. Mr. Shimkus, you're recognized for 5 minutes.
Thank you, Mr. Chairman. My mic is really loud, so I apologize. I don't usually need it this loud, but for Mr. Sununu, just aside, you mentioned that Congressman Harold Ford was with you. Is that senior or junior? It may dictate how we feel about your testimony. A junior.
A junior, another classmate.
Send him our regards, will you?
Will do.
I always believe, and I pulled up the organizational chart of the FCC, because I always believe that a lot of times structure dictates process. And that even though the structure is determined by the commissioner, in a lot of your opening statements, I don't think you were asked to look at structure, but I would ask you after this hearing if you have comments on structure to get back to us, because I do believe that some of these bureaus were established, as Senator said, you know, when there was a quasi-monopoly 1934, and then we've kind of, like building a home, you just take out walls, you put a different roof on, you extend, and I've always been amazed at how with the convergence of technology that we don't have a convergence of regulation. And I'll give you an example, I think, hopefully. We have no Internet Bureau. There's no Internet Bureau, so if you are overseas and you're going to call on Skype on a Wi-Fi system, you have no universal service fund, you have no intercarrier compensation, you have no local taxes, you have last mile issues that aren't compensated for. It just seems to me that if someone doesn't talk about structure, then the policy applications of the regulations, and I don't want to get into big detail because a lot of you didn't talk about structure, and I want to lay that out if you would get some structure. But Mr. May, you've signaled.
Well, I would just say briefly, I appreciate your concerns. I actually recommended several years ago that the Commission create a broadband bureau, even if it would have subdivisions that still dealt as it would with wireline and so forth. That might be useful, but I just would take the opportunity to say quickly that ultimately, to address the issue that you're talking about, and Senator Sununu.
Quickly, I'm running out of time.
You need to actually change the act to get rid of the silos that are presently in the
That's my point. I mean, I've always been concerned about the silos. Let me go to Dr. Cooper. I want to confirm that when my colleague, Ms. Eshu, asked about on the sunshine applications, that you agree that the sunshine applications in the draft you would support.
I'm okay with the sunshine application as a general proposition. I have two caveats. One, the reporting of those partial meetings, I want transcripts, not summaries. And I want transcripts of ex parte communications too, because those ought to be fully part of it.
Okay. I read your written statement.
Yeah.
And so when she asked that and you didn't object, I wanted to get clarity.
And I also have.
That's fine. I need to go. I need to go to the next. I have a lot of my friends in I've been really involved in the presidential executive order on jobs, which he did in January 18, 2011. And I really focus this on the EPA, that there should be a cost-benefit analysis and a job on new rules and regulations. The Blue Dog Coalition sent a letter to Chairman Janikowski asking him to at least voluntarily comply with the President's executive order. Mr. May, what are your comments on the Blue Dog letter? Have you seen this, and do you think that the FCC should do a cost-benefit analysis and a projection of possible job creation activities in the rules and regs?
I think it's useful that it do those things, and I think the recent executive order and President Obama's op-ed suggested as much generally, but I appreciate there may be some exceptions for minor rules and so forth, but in general, it's a useful thing, and here's why, just in sum. Because the FCC, for most of its history, has been oriented around this public interest standard, which is, as we discussed earlier, completely indeterminate, means whatever three commissioners say it does on any given day. This type of requirement, Congressman, would get the FCC oriented in today's competitive environment to doing the type of more rigorous economic analysis it just hasn't had a history to do or the inclination to do. So it's a useful thing.
Mr. Chairman, my time's expired.
Gentleman from California, Ranking Member Waxman, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Levin, I wanted to ask you some questions. I think it was very helpful to have you here because you're in a unique position looking at these issues from an administrative procedures point of view. You don't come here with any biases about how the FCC has performed, and you don't have an agenda before the FCC, so your position is unique, and it's, I think, very helpful. You raise a number of concerns and caution about the potential inflexibility, burdens, and unintended consequences of this bill, and I want to ask you to elaborate a bit on those concerns. What are the risks of moving forward with the approach outlined in the bill?
With what?
The risks. What are the risks of moving forward with the approach outlined in the bill itself?
Oh, well, I think on particular provisions, it could be too confining to say you have to have an advance notice of inquiry before every rulemaking proposed rule or a notice of proposed rule. You need two of something, because sometimes the agency has a pretty good idea of what it's going to do. Rather than have 2 rounds of discussion with the delay that would cause, you give the public at least 1 shot to comment on what the Commission wants to do, and that may well be enough. You don't need to build in an automatic 2nd round. Likewise, you don't necessarily need a reply period if there was no real opposition in the first period, or if all of the comments came in early in the period. People will have had plenty of chance to reply during the regular comment period to have a mandatory second period means you're building in a delay for no practical benefit.
Let me ask you about the cost-benefit analysis that's required under this proposal.
Right.
You concluded that this kind of scrutiny prior to issuance of highly expensive or consequential regulations may be appropriate, but for routine regulations, such a requirement would not be cost-justified. Expand on that.
Sure. So compare this with the presidential executive orders, which is the model, I think, for what the committee intends to do. They say that for all rules, you should make a reasoned assessment of the benefits and the costs. Now, in that sense, it's just saying think about the pluses and the minuses, and I think that's simple. But a true cost-benefit analysis, as we usually use that term, is a rigorous, sophisticated, and expensive analysis with a qualified policy analyst, and the executive orders limit that to situations where you have a very consequential rule. For a minor rule, it is an overinvestment of resources that agencies can ill afford to squander, and so to that extent, I think you have a disproportion between the executive order model and what the bill contemplates.
What do you think about the ability of the Administrative Procedure Act to allow the FCC or any other agency to evaluate the pluses and the minuses, the costs and the benefits?
Well, one thing to keep in mind, and I think this gets to the thrust of your question, is that an agency will have to analyze the pluses and minuses of the bill anyway, because it has to survive a pretty hard look on judicial review. There's also oversight, such as this committee provides. They'll have to answer the questions. And as far as the APA itself is concerned, they have to write a statement of basis and purpose to explain what they're doing. So to that extent, there is an expectation that they have to address the merits seriously. I don't think you necessarily need to add on to that with an FCC process provision.
What are your thoughts about the idea that this legislation is just focused on one agency? Should we be taking a broader approach with reform proposals where they're needed?
Well, I have endorsed an experiment with respect to the Sunshine Act, so I don't want to rule out categorically that you might do something agency-specific and see how it works. However, I think if you're going to think about issues of that kind, you should be not do something just to improvise. At least you should be very attentive to developed understandings in the administrative law field. And if you're about to do something that departs from it, you should be very cautious and rethink what you contemplate.
And then lastly, how does this legislation compare with related recommendations adopted by the Administrative Conference just last week?
I think in some ways it is parallel, but it also, I think, probably is a little stricter. And the final text hasn't been released, but my general understanding of what ACUS will say is that reply comments are good where appropriate, that at least 30 days or 60 days of comments should usually be available, but it doesn't provide that it should be 100% of the time.
Okay, thank you. Thank you, Mr. Chairman.
Thank you. And I'm going to exercise the prerogative of the chair with unanimous consent so we could all recognize one of our staff people, David Rettel, whose wife last week gave birth to their first child, Benjamin David Rettel. We've asked David to submit a photo for the record for this hearing.
Reserving the right to object.
Oh, yeah. We would hope on at least this matter we could have bipartisan. With that, thank you and congratulations to David and his wife and to the arrival of Benjamin David. There will be other announcements later in the year. Mr. Barton, we recognize you now for 5 minutes.
Thank you, Mr. Chairman. We hope that was not an open and transparent process.
Nor was it streamed on video.
Yeah, right. Right. Anyway, we want to welcome former Congressman and Senator Sununu, good colleague, good friend, and I also think an engineer before this committee. I have long been a proponent of FCC reform. Had a bill with several other members of the committee in the last Congress, have a bill in this Congress, and I plan to be a co-sponsor of the draft that Chairman Walden has circulated for comments. So I think this is a good thing, a good day, and I think it is high time. I have a few questions I want to ask for specific witnesses, but if anybody has a specific comment, feel free to chip in. The Section 5A, Subparagraph B, transparency reform that would require the Commission to establish internal procedures to provide adequate deliberation over and review of pending orders, publication of draft orders before open meetings, minimum public comment periods. Mr. Sununu, are you supportive of that?
I am.
Is there anybody on the witness dais that is not supportive of that, the transparency issues? Let the record show that everybody seems to be supportive. What about 5A subsection C, sunshine reform, that would allow 3 commissioners to meet for collaborative discussions if they do so in a bipartisan manner, which means that it has to be at least one member of each political party in consultations, and they also have to have the Office of the General Counsel to do oversight. Is anybody opposed to that? Mr. Cooper?
I would like a full transcript of any of those meetings as opposed to summary.
Okay. I don't have a problem with that. And by the way, Mr. Cooper, it's good to have you back. You probably have enough standing to get a pension from this committee as many times as you've testified, so we're glad that you're back. Let's see, let's look at the Section 5A subsection G that refers to shot clocks, which would require the Commission to establish shot clocks for each type of proceeding. Is that generally approved by everybody? Okay, looks like you're doing good, Mr. Chairman.
On shot clocks, I have one concern. I want the shot clock to run when the record is complete.
When the record is complete.
We've had a problem in merger review in which the companies aren't forthcoming into providing the data, and months after the shot clock starts, we all of a sudden get a big data dump, and we get them screaming about how it's taking too long. So I think the Commission should be allowed to build the record first and be comfortable that it has the complete record, and then this shot clock should start.
Okay. My last question in the last minute is Section 5A, subparagraph J, the transaction review reform. This would preserve the Commission's ability to review transaction, but would require conditions for those transaction reviews to be narrowly tailored to remedy harms that arise as a direct result of the transaction. What's the general view of that?
Well, my testimony, I criticize that as unnecessarily undermine the ability of the agency to deal with this dynamic market where mergers change the structure.
You want to tweak it, you want to eliminate it,
I don't believe the standard needs to be changed.
You don't think it needs to be changed?
I don't think the standard.
The gentleman next to you, Mr. Ramsey, what's your view on that?
I just wanted to pipe in here and say I'm a government lawyer. I'm not allowed to take positions that disagree with my clients, and in this particular case, my clients haven't come to any consensus on that provision, so I have.
And your clients are the NARU?
State Public Utility Commissioners, yes,
okay. Sir. Mr. Sununu, Senator Sununu.
I answered to just about everything. I think the real issue here is the one with regard to the voluntary considerations. And people are frustrated by the fact that at times the Commission seems to have sought out and imposed voluntary considerations, we all know what that means, that are outside their jurisdiction. So this is really as much a question of how to ensure that the commission stays within its jurisdiction as it is to determine whether or not there should ever be a voluntary consideration or whether the public interest standard is or isn't being misused. It's a question of finding language and finding a process that was consistent and that ensures that the commission stays within its jurisdictional boundaries. And I think that's what the intention is of this section.
Mr. Cooper, before...
And I have proposed a way to deal with that, which is that those conditions should be subject to comment and review in the form of Tunney Act approach, which would expose abuses. And that, I think that's a way to get at the abuses, but also preserve the authority to really deal with the issues that the merger proposes.
Okay. Mr. Chairman, I think you've got a winner here. It obviously needs to be tweaked some, but you've worked hard on this and you've listened to a lot of people. I'll have a few minor technical changes I wish to suggest, but I hope we can introduce a new bill and move expeditiously to move it through subcommittee and to full committee. This is something whose time has come. I yield back.
Thank you, Mr. Chairman. I appreciate the good work you and others on this committee have done for many years in this area, and I think we are on the cusp of having good legislation here that does need some tweaks, and we intend to work best we can in a bipartisan way to get that done. So with that, now I'd like to recognize the gentleman from Michigan, my friend and esteemed colleague, Mr. Dingell, for 5 minutes.
I thank my dear friend, the chairman, for this recognition, and I also express my thanks to my dear friend, Mr. Doyle, who is always kind and generous in his dealings with me. And I'd like to welcome back Senator Sununu. Welcome back.
Thank you.
It's good to see you again. These questions to Professor Levin and Ms. Abernathy. They will require yes or no. The draft bill requirement says that the Commission will complete an identification and analysis of the market failure that prompted a given rulemaking seems to be a little much. Does the Commission engage in rulemakings that are not prompted by market failures? Yes or no?
Yes.
Professor?
Well, I'm not a Commission FCC specialist, but I would expect the answer is no.
Thank you.
That some of them do not relate to market force.
The next question indicates to me, rather the question indicates to me that the draft bill's failure analysis requirement is then at least superfluous or worse, unnecessary in many cases. Am I correct in that feeling?
The cost-benefit analysis? You're correct.
It would be unnecessary in some situations.
All right. Now, again, to Professor Levin and Ms. Abernathy. The draft bill seems to require that the Commission perform a cost-benefit analysis on every rule that may impose additional burdens on industry or consumers. Is that correct?
I think that's what it says, yes.
I believe that's what the bill says.
Now, again, to Professor Levin and Ms. Abernathy. I believe the requirement is, again, overbroad and would require the Commission to devote many of its finite resources to performing such analysis. Do you agree, yes or no?
I agree.
I agree it's overbroad.
Now, again, to Professor Levin and Ms. Abernathy. Further, is it reasonable to assume that the Commission has neither adequate staff nor funding with which to complete the cost-benefit analysis of every rule that imposes additional burdens on industry or consumers? Yes or no?
It's reasonable to assume the answer is yes.
Ms. Abernathy?
I don't know.
Okay. Now, if this be the case, it would appear then that the Commission would require additional funds in order to comply with the draft bill's requirements. Is that correct?
Presumably.
Okay. Or we might assume that the FCC will be doing more to accomplish less at greater cost. Is that an unfair assumption?
So I would assume.
Okay. Now, to all witnesses, this again to the last two witnesses. Finally, I come to a matter of personal interest. In the Congress in the past, I've introduced legislation to amend Section 10 of the Federal Communications Act to require the Commission act on a forbearance petition within a year's time. Forbearance as a result of Commission inaction and action that takes place as a result of Commission inaction appears to me to be very bad policy. Now, to all of our witnesses here, starting with Senator Sununu, would you support amending Section 10 of the Communication Act as I have just described to eliminate the forbearance that is practiced by the Commission, leading to decisions being made by simply inaction on the part of the Commission?
To eliminate the forbearance or to set a time limit of 1 year?
Well, tell me what you feel. Should we do it with a have to act on it within a year's time?
I think any time you can set a clear time frame for action, it's going to add certainty to the regulatory process. I don't know if 1 year is the right amount of time, but certainty in the regulatory process is likely to be a good thing.
Thank you. Ms. Abernathy, yes or no?
I agree with the additional clarity around the forbearance process.
Mr. Ramsey?
We're on record with agreeing with the concept of shot clock, so I guess the answer is yes.
Mr. Cooper?
Justice delayed is justice denied, but it needs to be worked both ways. So when complaints are pending at the Commission, they languish for years. If you're going to have a shot clock, it ought to be both to the favor of the
Maybe
public
we ought to
and
fire
the
the
industry.
damned Commission if they can't come to a decision on these matters, or give them more money. Let's see. Mr. Levin?
Well, I don't do FCC law, but administrative law authorities generally are skeptical about Congress imposing too many statutory deadlines, because the upshot may be that those deadlines will drive the process more fully than they should.
Let's not debate that, but it seems like poor sense to have the Commission just simply saying we haven't acted, so it's going to become the rule, or it's going to become law, or it's going to become the regulation. That appears to me to be very bad. Do you agree?
I'm sorry, could you repeat that?
Well, the Commission just sits around and twiddles its thumbs, nothing happens, and all of a sudden we have a new rule. Doesn't seem like good sense to me. Does it make sense to you?
I think they should proceed expeditiously. I think the idea of establishing deadlines for themselves is good. But when you talk about, if you were talking about it, legally enforceable deadlines, you will often have too much control by outsiders.
I disagree with your proposal because it shifts the whole forbearance thing around. It was included in the Act to be deregulatory, and that's why the provision says if the Commission...
Thank you very much. Mr. Chairman, I say this with respect. If our intention here is to focus on process reform, I would urge it to be done deliberately, transparently, and with adequate participation of all affected parties. And after all, we should avoid the mistakes of the agency that we seek to reform. Mr. Chairman, your courtesy is appreciated, and I thank you.
Thank the gentleman from Michigan, and now turn to the gentleman from Ohio, Mr. Latta, for questions. I made a mistake. Ms. Blackburn.
That's quite all right. I know I'm hard to see over here. I want to stay on this issue of forbearance. And Mr. May, I want to come to you because you've talked about the reforms that are needed in Section 10 and then regulatory review, the periodic reviews that are needed in Section 11. And I appreciated your comments. And so why don't you elaborate a little bit on why we should, how including evidentiary presumption to forbearance, how it would enhance the likelihood of the Commission in reaching a deregulatory decision? Because I think that's, as we look at reform, that's going to be a key nugget for us.
Thank you, Representative Blackburn. Here's the deal in a nub. These two provisions, forbearance, regulatory review, if you look at them, were clearly put into the 96 Act to be used as deregulatory tools. That's evident on the face of those provisions. The fact is they've only been used very sparingly by the Commission. They haven't accomplished much deregulation, even as the market has developed, become much more competitive. So I think the Congress, through a pretty modest fix, could address that situation in this way, not by changing the substantive criteria that are in the forbearance and regulatory review provisions, but again, when you look at them, they're addressed to the development of a competitive market. It doesn't change the substantive criteria, but I would add a sentence that essentially says that in acting on a petition or in doing the regulatory review proceeding, unless the Commission can find by clear and convincing evidence that the criteria have not been met, that it shall presume that the rules should go away. So again, you're not changing the criteria, but you're adding an evidentiary presumption, because you ought to wonder why these two provisions, which are unique. I think even Professor Levin, who's looked at other agency statutes, for many years I've challenged anyone to find another forbearance provision like this in another statute, and no one's done that like this. It seems to me if the provision is there, you ought to make it useful, and you could do it by just that shifting an evidentiary burden. And to me, this is the most important thing the committee could do, and it does fall in the realm. It's sort of at the line between substance and process in a way, but it should be done, I think, if the committee wants to address the existing situation of existing regulations, because your draft principally addresses regulations going forward.
Okay, thank you. Let me reclaim my time, and I've got a couple of yes or no questions that I want to give to each of you. Commissioner McDowell gave quite a hefty statement calling for a full audit, a full and public operation, financial, and ethics audit of everything connected to the FCC. Mr. Sununu, starting with you, yes or no, do you support having that full audit all the way down the line?
I think as a matter of practice, that's good policy.
Okay.
I agree, it's good policy.
Okay.
NEDRIC has no position.
Pardon me?
My association has not taken a position on that.
No position. Okay.
As far as I can tell, the FCC is no better or worse than any other agency. The Inspector General and the laws of the United States cover the problem, so I say
right.
no.
Okay, Professor?
Well, I'm not an FCC authority. If I had to stake out a guess, I would probably give an answer like Mr. Cooper's.
Okay. Mr. May?
I think it's a good thing to do, not every year necessarily, but it wouldn't be a bad thing to do.
Okay. So 1 no position, 2 waffled, and 3 yes. So I will take that. But remember, these are yes and no questions. All right, 1 more. Yes or no? Okay. Do you think that Congress should be in the position of defining the role for the FCC and telling the FCC what to do, or should the FCC continue doing what they're doing right now, which is trying to tell Congress what to do? Mr. Sununu, yes or no?
Well, it's absolutely a congressional prerogative, and again, in my opening statement, I think that in addition to this draft legislation, we need to look more broadly about the underlying premise of the 34 Act, the 96 amendments, and view this as a competitive world first and not as a natural monopoly.
Okay.
Yes, Congress defines the scope of the FCC's authority.
Thank you.
Yes, Congress defines the scope of the FCC's authority and can tell it to adjust its procedures as suggested in the draft.
Congress did that in the 96 Act.
Okay.
Yes, Congress should set the bounds of the Commission's actions, but it should give discretion to the Commission for things that require more flexibility than Congress can get around to addressing in specific terms.
Okay. Mr. May?
Yes.
Okay, so we've got 4 that say yes, 1 that give a little bit more, 1 I think is uncertain. So I thank you all. Remember, yes or no, you did fairly well for being here in Washington and limiting your words, even though you couldn't give me a yes or a no, and I yield back.
Thank the gentlelady for her questions, and I turn now to the gentleman from Pennsylvania, Mr. Doyle.
Thank you, Mr. Chairman. I'm very concerned about this section of the draft that requires the Commission to issue a notice of inquiry for every single proceeding. I think in some cases this could cause serious harm to consumers and the public safety, and I would urge my colleagues to think back, for example, to the proceedings a few years ago when VoIP customers couldn't make 911 calls, and the FCC needed to act quickly to enact E911 rules. This is just one example. Another might be the rules required to implement the legislation we just passed to expand low-power FM radio, which the Commission is currently working on. I know that Professor Levin has already voiced his opinion on this, but I would just ask for the rest of the panelists, given these concerns, is there a strong enough reason to require a NOI for every single proposed rulemaking? Why not just leave this up to the FCC? If we could just go down the line.
Well, I have to believe that there's an in-between. I think as a matter of policy, the notice of inquiry is a good idea. There certainly may be examples, either in the past or hypothetical, that where it might not be the ideal situation. But it's important, if you're going to make exceptions, to define those circumstances and those exceptions as clearly as possible. I mean, you defeat the whole purpose if you just say, well, the FCC can decide, because you're going to have less clarity and less definition in the process.
Ms. Abernathy.
I think an NOI as written is overly broad, and so it should be circumscribed to some degree so that you don't waste resources and create delays. But I think in concept it's a good idea for many proceedings.
Mr. Ramsey?
I agree with actually the statements of both of the people that preceded me. I believe, you know, typically a rush to judgment means you ran too fast, so I like the concept of having a notice of inquiry in most instances. I would note that in emergency circumstances, the APA allows the Commission to bypass even a notice of proposed rulemaking. So in those circumstances, there's already a mechanism, but the question is how to create a different, how to set the standard, as Mr. Sununu said, for when you don't have to do the NOI, which is not an easy thing to address.
Would the gentleman yield for a
Yes,
second?
sure, Mr.
On page 3 of the draft, we incorporate that APA emergency exemption.
Oh.
So I would draw your attention to that. And on the second page, it's actually, if they've done an NOI, an NPRM, or a notice of petition for rulemaking in the last 3 years, that qualifies.
But it still requires 2 rounds of comment?
No.
No, you don't require,
There's an or in that paragraph. I'm reading that, the first paragraph says or, as far as I can tell. And so maybe I've misread it. And it is really important that we get this right, because I believe in the opportunity to comment. But I don't think it's necessary for 2 rounds of comment. If the agency proposes a rule and builds a record, then that meets this. And I see that or, it says one or the other. So it's not, it doesn't say a notice of inquiry and these others. It says or. Now, maybe there's someplace else in here where we get the impression of the and, but it's an or.
Mm-hmm.
That's my reading of it.
Mr. Levin?
Well, the Chairman's correct that the bill as written exempts the true emergency situations where you can proceed with no notice and comment. But that having been said, we should also think about situations where there's some urgency about getting just the basic notice and comment done, and having 2 rounds of comment is unwarranted. So you should leave some flexibility to say we don't need the advance notice in this particular situation. The public still gets 1 shot at commenting and saying it's a bad idea, change it, etc. But you don't need the extra round, and sometimes that would be imprudent.
But I guess the trick is how do you write that into the bill? Mr. Sununu brings this up, that you know, do we just leave this at the discretion to the FCC, or is there a way to create some language that would allow it to happen, what you've just suggested?
I think it needs some consideration, but one idea I suggested in my draft is that you might set up the procedure and say the agency can, for good cause, bypass it, and that term is usually read to mean a very good cause, not because you feel like it.
Sure. Mr. May?
Yeah, just briefly, this is a provision I'm generally not in favor of in the draft for a lot of the reasons that Professor Levin has talked about, but here's what should happen. The reason it's here I think it's because the FCC, especially in recent years, over both all commissions, it started to draft notice of proposed rulemakings in a much more open-ended way than it used to back when I was at the commission a long time ago, and it's I guess responding to that. So but it does it's likely to increase the time that the FCC could act on things that it does need to act on. Remember, I talked about Chairman Powell saying that the commission needs to be able to act in internet time. So this is, I'm not sure, the right way to get at that. Maybe just if your oversight would get the FCC focused on drafting rulemaking proposals that actually propose specific things, if not precise rule language.
Sure. Thank you, Mr. Chairman.
Thank you, Mr. Doyle. We go now to Mr. Scalise for 5 minutes.
Thank you, Mr. Chairman. It was brought up earlier that a lot of us have concerns, want to put some real structure in place for the FCC, not just for clarity in the industry, but also to move it away from, for what many of us view as an agency that's starting to implement their own political agenda, as opposed to an agency that should be focused on regulations as it applies to existing law. I want to ask, and I want to start with Mr. May, when we look at some of the mergers that have come through recently, and of course there are still mergers pending before the FCC, there's a provision here in Section J of this draft. It says the Commission may not consider a voluntary commitment of a party to such transfer or transaction unless the Commission could adopt that voluntary commitment as a condition under Paragraph 1. Let me ask you, in your experiences from what you've seen with some of these conditions that have been placed on mergers at a time where companies really are very vulnerable to some of the pressures that would be put in place to agree to something they might not otherwise support, and those preconditions placed as a condition of a merger. If you can address that in general, but also as it relates to what you're seeing here in the language in the draft.
Well, I think the language in the draft is good, and I'm enthusiastic about this provision. I said in my opening statement I'd actually like to see the merger review process reformed even further. But this is useful because what it does is at least try and put some constraints on the FCC from going too far afield by tying the FCC's extraction of voluntary commitments to conditions that are narrowly tailored to remedy a harm that arises as a direct result of specific transfer or specific transaction. Now, there can still be disputes about that, but at least that does confine it, and that's a useful thing. The problem right now, and this is why this is so important, the only constraint right now is the public interest standard. And the public interest standard, of course, is completely indeterminate, and I can think of mergers where the FCC has imposed a condition, or there's been a voluntary commitment offered not to outsource jobs overseas, for example, in one merger. Well, that might be a nice thing to happen as a policy, but it didn't have anything at all to do with that particular merger at all, and there have been examples like that, and it gives the process an unseemly flavor when at the last minute, 2 days before a merger, you see voluntary commitments offered up like this.
And how about as it relates to the entire industry too? Because there are some conditions that maybe currently or in the past that have been placed that don't just affect the entities involved in the merger, but also could be impacted industry-wide.
Well, and that's true, and it also, of course, happens, the other way around, sort of perversely, that you can have a condition imposed, extracted by the FCC, and I'm using the word extracted because, again, these things generally happen at the last minute, where a condition that ought to be industry-wide, imposed on an industry-wide basis, if at all, if it's going to be imposed, one party, the party to the merger, is now subject to it, and that seems not to be really equitable. But then what happens is often that condition sometimes is then used going forward by the FCC as a proposal then to apply to the whole industry, so it becomes a bit of a precedent, if not a legally binding.
Right, and I think again that's a good condition because it is a problem we've heard about, but it's actually been implemented in that's probably still being used today in some of the others. I want to ask Ms. Abernathy a question. As it relates to the annual reports, we've heard a number of complaints that the annual reports that the FCC has to comply with today, by the time they're filed, they're outdated. It takes a whole lot of work to put in, and then they're filed and really aren't that useful. This draft in Section K really kind of lays out a different process of putting a communications marketplace report in place that might be a little more conducive to the changing technologies. If you can maybe address both what you're seeing in the draft, but also as it relates to the current practice of these annual reports and whether or not they're even useful.
I think if you implement new reporting obligations and eliminate some of the old ones, then that makes a lot of sense because, again, some of the reports were built around the old silos. And so the information, it takes a lot of time and money to gather the information, and yet it probably isn't providing a great deal of beneficial competitive analysis for Congress. So I think there's got to be a better reporting way, and this is a proposal that I think would start put you in the right direction.
I'm sorry, if I could make an observation on that point, though. The language that's here in the communications marketplace section, identifying challenges and opportunities in the marketplace, the jobs and economy, frankly, it begins to make the FCC sound like an economic development group, and that's simply not what it is. I think perhaps what we're trying to get at here is that the Commission should be more focused on evaluating the competitive state of the marketplace, the number of players, price trends, new products, innovation in the space, and taking that into consideration in their regulatory and rulemaking process. So I might encourage you to look a little bit more carefully at that language in order to, A, avoid unintended consequences, avoid creating new areas for the FCC to engage in regulation, and instead focus it on making sure that we've got a regulatory authority focused on the current competitive state of the marketplace.
We appreciate that.
Appreciate your comments, and yield back, Mr. Chairman.
Thank you. We do have a vote on in the House floor, but we should have time for Mr. Latta for 5 minutes. And as he prepares, I would really appreciate it, as you've heard the discussion among yourselves and with us, if you have specific recommendations for improving the language in the bill that are not referenced in your own testimony, it would be most helpful to get that to us as soon as possible. Thank you. Mr. Latta.
Well, thank you, Chairman. I greatly appreciate you holding the hearing today, and all the panelists for being here. Greatly appreciate your time. And I also appreciate the Chairman's discussion draft. I think it's very, very important. You know, we all have, pardon me, we have lots of folks coming through our offices all the time talking about what's happening out there. And you know, the FCC's no different from what I've heard from a lot of different folks, is that we have to really go in and look what's happening there because of what it could be stifling businesses out there. And one of the things I have done, I've also got a bill out there on for a cost-benefit analysis for the FCC when they're promulgating rules, and at the very beginning and also at the final rule. And because, you know, the things that we've heard that they're looking at, of course, are either, you know, what those cost benefits would be that either would or should the FCC consider, and you know, the costs are largely the cost of businesses of complying with a new regulatory regime, i.e. creating new compliance regime, training employees, changing billing, other back office systems. Yeah, the lost revenue that would businesses could be would be lost from the new prohibited engaging in particular business models that would be prohibited under the new regulation, and the cost of productivity into businesses. And one of the things, if I may, Ms. Abbott, if I could ask you first, is in your unique role as a former FCC commissioner and also at Frontier, what you would see would be able to comment on this idea from the, you know, the FCC's perspective and also from Frontier, if they would have to do a cost-benefit analysis.
I think it's appropriate for a number of proceedings to engage in the cost-benefit analysis because at the end of the day, if the costs drive up our cost to consumers and the overall information, incremental information that is potentially provided to the FCC is de minimis, that makes no sense. And sometimes what happens in the context of looking at various rules and regs is the commissioners have the best of intentions, but they haven't really thought through the costs and the burdens on the industry, and it's backwards. And so I think it would make a big difference.
Let me ask you this. Are there, looking at what's happened in the recent past with the FCC, could you comment on any more recent rules that would have benefited from a cost-benefit analysis?
I could get back to you in writing afterwards,
that.
just because I need to look back.
I appreciate that. Mr. May, I know in your testimony that you've addressed on page 2, your last paragraph there, that you said in the taking them generally in order that they appear in the bill draft. I want to especially endorse a provision that would require the agency, and you go on to also state that perform a cost-benefit analysis. Just get your read on that a little bit farther on the cost-benefit analysis.
I think generally this would be a good requirement to impose on the FCC. I take Professor Levin's point that it's worth thinking about whether it should be for every rule, and the answer is it may not be, but there's a lot of economically significant rules that the FCC proposes. Now I think of bill shock, net neutrality, the data roaming bill it just did. All of those are the types of rules that have cost and benefits, and I think the FCC, obviously it does some of this now, but as I said earlier, because historically it's tended to focus, again, in 103 places it has authority to act in the public interest, and because that's so indeterminate, it has, in my view, a bit of with respect to all past commissioners, it's got a bit of a mindset, to think of things in a way that's not economically as rigorous as it should be in today's environment, which is at least increasingly a competitive, fast-changing marketplace environment.
Yeah, in my remaining time, Mr. Ramsey, I know on page 7 of your testimony today that you state that still logically analysis of a rule's potential benefits and costs as well as milestones for its review could focus available resources and expertise on the efficiency of any proposed rule. And just your comment on any other comment on cost-benefit analysis.
Well, the only thing I said in my testimony is true is that the nature of regulation and the nature of regulatory oversight is a balance of competing interests. The APA already requires agencies to specify the basis and explain why they're doing things. We haven't taken a specific position on the application of a strict cost-benefit test, so I can't speak to that. But I think I also noted in my testimony that it's certainly consistent with executive orders dating back to, I think, Gerald Ford.
Thank you very much, Mr. Chairman. I see my time's expired, and I yield back.
Mr. Latta, thank you for your participation in the hearing. I want to thank all of our subcommittee members for their participation, especially thank our panelists. You've been most enlightening for all of us as we work to improve this draft. And as I said, I really would appreciate any specific recommendations on how to make this better and more workable. So with that, we thank you again, and this hearing is adjourned.
Nice job.
Pleasure.
It was good. I agree with you on that NLI.